Aye.
Good morning. My name is Christopher Iannella. I will chair the meeting. To my left is Councilor DiPaolo. A few of the other councilors should be in momentarily. Good morning to you and good morning to your wife. At this point, I'd like to read a letter addressed to the Governor's Council dated June 16, 2021. Dear councilors, I'm pleased to nominate Michael Sherry to the position of Administrative Judge of the Industrial Accident Board for a 6-year term. Sincerely, Charles Baker, Governor. So at this point, Mr. Sherry, before we hear from you, I know you have folks who want to speak on your behalf. I did receive a call from Attorney Michael Occasion, who I have the highest regard for. My understanding, if I'm right, he has a prior commitment. He was scheduled, this hearing was scheduled for an earlier date, but because of a scheduling conflict with the governor's office, our office, and whatever else, he now is no longer able to be here, but he did write a letter and they'll be part of the record.
Thank you.
So at this point, we'll hear from Michael O'Malley. Good morning, sir.
Good morning. Thank you so much. My name is Mike O'Malley. I'm a member of the Massachusetts Bar, and I've been a member since 1983. My connection with Michael is that I worked with him as a colleague and with him in the same office at Liberty Mutual for more than 20 years. And in that regard, initially Michael worked up at the Worcester office for Liberty Mutual, then the Andover office for Liberty Mutual, but then he joined the office that I was assigned to in Raynham, Mass. In 1999. Now, I'd just like to speak to 4 points concerning what I think is Michael's qualities and qualifications for this position as a TIA judge. Oh, and by the way, just to let you folks know, although I did insurance defense work for 25 years or so, for the last, I don't know if these years add up, but for the last 10 years or so, it's been predominantly, if not exclusively, plaintiff's work.
So you're on the right side.
How about this? I'm on the side that's now paying the college tuitions for the O'Malley families. And then in connection with my years of experience, my practice has been predominantly civil tort, either insurance defense or a plaintiff side tort. But I did, back in the old days of Liberty Mutual, we had to be sort of a jack of all trades. And I did do workers' comp for a year or so back in the 80s. But just hitting on 4 points, which I think speak to Michael's qualifications. And first, his work ethic. At Liberty Mutual, in an in-house position, Michael has had to deal with work on a extremely high volume of cases, and that doesn't just go with his current caseload in the Boston office, but throughout his career. But in connection with that high volume of cases, being in-house counsel, there was also an expectation that there would be quality representation of the particular insureds, both the workers' comp arena, but also in the tort arena when you're representing individual insureds. But Michael, notwithstanding the high volume of cases, the high expectations of quality representation, I always found Michael to be not only extremely efficient, extremely diverse, extremely organized with regards to his practice, but he was always prepared. And whether or not that is that's a workers' comp case up at the DIA, or back when he was doing tort up at the BMC or Brockton Superior Court. Next, I'd like to speak to just the knowledge base I think Michael will bring with him should he be appointed. Just with regards to his knowledge of Chapter 152, his knowledge of the Act. Michael has a thorough working knowledge of Chapter 152, but it goes beyond just the 4 corners of the Act. The black and white verbiage, the regs, the statutes, et cetera. I think with Michael's years of experience, he also probably encountering everything under the sun as it pertains to the handling of a workers' comp case. He will be thoroughly familiar and comfortable with applying that black letter law to everyday life situations that he'll see on a daily basis. Next, I'd just like to speak to Michael's familiarity with the Department of Industrial Accidents. This is a fellow you're not going to have to give a GPS for him to find his way to the Worcester DIA or the Fall River DIA. Michael is there, maybe not so much in the last year or so, but on a day-to-day basis. He is familiar with the lawyers, the judges, the support staff, the security staff, but as much as anything else, just his day-to-day interaction with the DIA, he brings with him, he knows what the expectations are of an effective DIA judge with regards to handling the volume of cases that a DIA judge will see. Well, and last but most of all, the temperament that he will bring with him to this position. And sometimes I'm accused of speaking in these broad generalities and just overflowing with glass half full. But Michael is a good person. He is considerate. He is a listener. He is even-tempered. And how about this? At Liberty Mutual, he's taken on a variety of positions, both in the trenches working the cases, but also as a supervisor and a manager. And Michael, over the years, has mentored tens and tens of young lawyers, young law clerks, and young law students. And I think that mentoring is just indicative of his ability to pass on to others his knowledge base, not only of workers' comp, not only of the tort system and whatever is expected in his managerial duties, but also how a lawyer is expected to act when he or she is in front of a judge, a DIA judge, Superior Court judge, et cetera, et cetera. So I will conclude with that, but I'm going to end on this note. Michael is following in some pretty big footsteps. Before him, we worked with Peggy O'Neill, and Peggy sits on the DIA. She's predominantly down in Fall River. Likewise, we worked with Dennis Marr, and although I am rarely in front of the DIA, I hear and I'm biased because I'm friends with both of them, but I hear rave reviews as to both of them. But before Peggy, before Dennis Marr, there was Lenny Jackson. I don't know if you go back to the Lenny Jackson days. He was a former Liberty guy, and Emma Jean Johnson. So I am hopeful that Michael gets this position, gets appointed to this position, and I unequivocally and without reservation recommend his appointment.
Thank you. Any questions of Attorney O'Malley?
I have no questions, but thank you for.
One quick question. I appreciate everything you said. My constituents, when I deal with employee, injured workers, everything you said is nice, it's sweet. Is he going to give the injured worker? I say I don't like him to be fair. If it's a close call, is he going to go on the side of the injured worker? Because this act is for the benefit of the injured worker. That's give me a sense on that.
I understand the statutory purpose of the act. How about this? I will answer the question in this manner. I don't think there is a single plaintiff side, employee side attorney in the Boston area, Fall River area, Worcester area that will have any beats having Michael Sherry hear his or her clients.
That's good enough for me. Thank you. Thank you. At this point, we'll hear from the nominee, Michael Sherry. Give us a brief background as to your work history, your education background, and why you think this council should approve you as an administrative judge of the Department of Industrial Accidents.
And I'd like to start with some thank yous because it was a long process of interviews during some very trying COVID situations, and I appreciate all the consideration I've gotten. I'd certainly like to thank you, Councilor Iannella, for chairing today's meeting, and all of the members of the Governor's Council who I've had opportunities to to introduce myself, to answer questions, answer concerns. The questions were good. The questions were things that I would have been asking if I was sitting in the position of passing on myself for this nomination. I certainly thank Governor Baker and Lieutenant Governor Polito for accepting my application and reviewing my application and feeling that I am someone that should be nominated for this position. Also, my meetings with the Judicial Nominating Commission with Lauren Green Petrino and legal counsel Bob Ross. That was an in-person meeting in kind of the high point of COVID, which was an interesting process, but a great meeting, a great discussion, and I appreciated that we went through some important issues. Also in that process, the interim director of the DIA, Sherry Bowles, and Senior Judge Omar Hernandez. And Judge Hernandez has been very supportive and very encouraging through the process, and I truly appreciate that, and I look forward, if my nomination is approved, to working under him for a foreseeable future, because he is a great person to work with and work for. And members of the advisory board who took the time to ask me questions. Many of them were on the employee side. Many of them had those similar questions, and I gave a similar answer that Michael gave, that I can't speak for an employee, but I know I've received many calls from employee attorneys, injured worker attorneys, who were supportive and said, I would have no issue bringing my case before you to decide. Certainly Michael Occasion for writing a letter in support, and would have been here if he could have, but I appreciate that he sent a letter that's highlighting my qualifications, and Mike O'Malley from coming in here today and speaking. Also my wife of 30 years, Ann Sherry, and our adult sons, Nick and Joe, for always being there and supporting my decision to pursue this opportunity and to serve at the DIA. And my wife probably has more public service experience than me, because I've been handling cases in law. She's been working at community bank, but as a community banker, she's worked closely with fiscal education, student banking programs, and working with our town's affordable housing trust to bring affordable and workforce housing to our community, which is a pressing need. And I applaud that she takes the extra time to do that. As far as my family, my dad was a World War II veteran who went on to work for the government as a map maker in the defense field. And he came from a generation where people went to work every day and never saw a doctor unless they absolutely needed to see one. And I really wish he didn't do that, because he may have still been here, or I may have still had more time to enjoy with him. And that's something I would bring to a DIA position, understanding that pressure, that people don't want to be out of work. And if they are dinged up a little, they'll continue to struggle through. And those are a lot of the cases we see. We see a lot of repetitive motion injuries where someone sucked it up for a while and they just got to the point they couldn't work anymore, and then the case got contentious. And from seeing how my dad went through that, that's something that resonates with me, as something that I would be able to see and be able to have that as part of my knowledge base in deciding those cases that people do struggle through when they probably shouldn't. My mother, Anna Sherry, is 95 years old, still plugging along, lives with us in Medway. She was a first generation US born in her family, worked in factories in Pawtucket and Central Falls, Rhode Island, went on to nursing school and to become a registered nurse, and did that for a number of years before transitioning to the role of a full-time mother for me and my brother Joe, and doing an excellent job at home with us. And again, another thing that brings to me from my experience going forward is that I saw what it was like to be in a single income family back in those days, and the sacrifices my parents made to make sure that my brother and I had everything we needed. And knowing that we're in a day now where we not only don't have many single income families anymore, we have multiple income and multiple job families. And that those are a very, very tough times to make ends meet. And that's something I would bring to the DIA, knowing that. I went to Boston College, and I put this out there, not to brag, but I was fortunate enough to play on the golf team there for 3 years. And the one thing that really taught me was that the spring semester golf schedule is very condensed. And we have to balance our school and our commitment to the sport in a month where every day there's something going on. And to me, that's something that really brought organization to me, really brought the need to be able to effectively review stuff in an efficient manner and to bring that organization that's required for a high volume like the DIA. While at the same time, at the DIA, it's a high volume, but at the same time, I have to understand as a judge that it's a part of a song of a friend of mine's. That's the phrase is, I'm a paycheck away from living on the street. And that's something I have to bring to my job. I know I have efficiency. I know I have to process so many cases to keep things moving. But at the same time, I have to understand that the injured worker could be a paycheck away from living on the street. And my decision on their case is something that is much more life-altering for them than me checking a box that I heard a case. Likewise, on the employer end, the other stakeholder, that they could be an experience modification or a self-insured retention away from maybe laying an employee off. So I have to take that seriously. At the same time, I don't have to make everyone happy. I have to decide the case by the law of an employee benefit statute. And if the law says that benefits are entitled, I award the benefits. At the conference level, where there is no witness testimony, it's only review of records, I have to determine, is it more probable than not that this employee will prevail? And if it is, then they should be awarded their benefits. And at the same time, I have to treat that case seriously. I can't make any of the stakeholders feel that I was running the place like a drive-through at a Dunkin' Donuts, that I considered what they had to say, that I heard their arguments, and while I may not have found in their favor, it was not because I didn't think it through, and address the reasons for the decision I'm making. And to me, that phrase is very important. And having that ability to put yourself in the shoes of the person or the people who are on the other side of the table from you, and making them feel that they were heard, their opinions were respected, and that they were considered. At Boston College Law School, another thing from my end, I got a great legal education there. But Boston College Law also always put the public service aspect of the law into the equation. And to me, this is an opportunity in my life to do service for the Commonwealth, to do service for the public, to do more service than just representing clients and their interests and their needs. It's a chance to do something bigger picture. And I look forward to doing that. And as Michael said in his presentation, when you work for Liberty Mutual, you know that it's drilled into your head, the close connection between Liberty Mutual and the mass workers' compensation system. That they were founded together, they were founded in that same context, and it's always something that you aspire to handle workers' compensation cases and to learn as much about the Act and the history of the Act. And as Michael said, we had many lawyers come through Liberty who went on to judicial or administrative judge positions at the DIA. And he named several. The other one I throw in as well on that is Judge Pearson. Barbara Pearson also was an ALJ at the DIA for a stretch of time. And again, some of the philosophies, I know your question, Councilor Ianello, was about the statute and applying it. And yes, I'm fully aware it's an employee benefit statute, and that's what it's there. That is what it's there for. That anything a tie or in the vicinity of a tie goes to the employee, because the employee is the one who's supposed to be benefited by this statute. They've given up the right to sue in tort for pain and suffering. They've got wage replacement, they've got scarring and disfigurement, they got medical. Personally, from my end, one place that it doesn't get seen at the DIA is the discussions I have with Liberty adjusters before a case gets into litigation. I get countless calls a day by an adjuster saying, should we pick this case up or should we deny the claim? And I always fall back to one of my core beliefs is that if the purpose of the Comp Act is to get injured workers treated and back to work, or back to work that is suitable for them, to do that, they need to have continuation of their benefits. If they deserve their benefits, they should be continued on their benefits and they should be receiving a check so they can focus on getting better. They shouldn't have to focus on the bill collector pounding on their door. Likewise, on the treatment end, if an employee needs treatment, it's reasonable and related, they should be getting their treatment to get better. Any of us who have done, although we're not doctors, we read a lot of medical records, we review a lot of medical records, we have clients with a lot of injuries. Injuries do not get better over time. Delaying treatment for months ends up with worse results, potential additional disabling conditions. And from my end, if someone deserves a check, they should be getting a check. If they need treatment, they should be getting treatment. And the employer should be making a bona fide effort to get them back to some type of work to transition into if possible. And if not, then the Act provides for those additional benefits, permanent total disability and things of the like. And I'm not afraid to decide cases. I know I'm at least going to not make one person happy. In many cases, I might not make two people happy, but that is how the dispute resolution system works. We do the best we can with the evidence we have. We make the right decision. We try to explain to someone that we've made the right decision, and we hope they understand it. And at the end of the day, that is what I believe I'm bringing to the table. I don't want to go on too much longer, so I will leave it open to any questions that anyone may have. But I certainly thank you for this opportunity, and I look forward to hopefully getting a positive result on my nomination.
Thank you. Counselor Kennedy, you have a...
I don't have any questions for you. We spent a lot of time on the phone.
Yes.
Quite a bit of time. I will say that I got a text from Judge Omar Hernandez this morning. I think probably everybody did, fully supporting your nomination, and he couldn't be here today. He's somebody that I have a lot of respect for. I can tell you that your counselor has been a big fan of yours and got very enthusiastic about your nomination, Counselor Iannella. You seem to have the background, the temperament. You get what the workers' comp statute's about. Just a few words I heard you say today in terms of it being about protecting the injured worker. So I'll be voting for you next week, and I look forward to it. Thank you.
Thank you very much. Counselor DiPaolo.
Yeah, thank you, Counselor Iannella. Good morning.
Morning.
Your presentation was thorough, and a lot of my questions were explicitly addressed. And I thought you raised an interesting point about workers who will delay treatment, will try to stay on the job, because most people want the dignity of work, and most people are living paycheck. Strike that. Many people are living paycheck to paycheck. And I appreciated that perspective and your sensitivity to the injured workers' situation and really their family's situation too. We just heard you indicate that when it's a close call, it goes to the injured worker, at least in the early stages, so they can continue whatever path they're on to get back to work. And finally, you addressed my final question was going to be the volume coming through and how you are going to be able to maintain your sensitivity to each individual case and each individual injured worker in spite of dealing with that volume. And I was very satisfied with that response. We heard great things from folks who've worked with you and who work in this field. And so I have no questions for you this morning.
Thank you very much. Counselor Marilyn Petito Devaney.
Thank you. Nice seeing you again.
Nice seeing you.
Quite a day out there. I followed an accident on the way, so didn't start out too good. So first of all, I want to thank you for all the time that you afforded me. It was a pleasure to meet with you. And you're now in the Hall of Fame for the Belgian waffle. First of all, what I saw in you when I met with you was compassion and empathy. And every judge needs those qualities, but especially these people looking to put food on the table. I like what you said when you wanted to, they asked you to add anything favorable or unfavorable. and you said that I believe my legal background has helped with empathy and putting myself in others' shoes. The DIA can seem like the same case 100 times over. So it is important to remember this may be an employee or employer's first experience with the process. They need to feel they were heard and their position was thoughtfully considered. As I am used to handling a high volume of cases and multiple proceedings a day, I feel I am equipped to handle cases efficiently and issue timely decisions. That's great. I want to tell you, I got a call from Omar Hernandez. He regrets he couldn't come to the hearing, but he couldn't say enough adjectives about you. He said that you are, you have empathy, you have compassion, you are so highly qualified, and you would be such an excellent addition to the board, and that you have the temperament that we need in a judge on the industrial accident board. So I'm sorry he couldn't be here. I want to ask you, you've had hundreds and hundreds. How many cases would you guess?
Over 30 years, 3,500 to 4,000.
Can you imagine that? Wow, that's great. And no contributions. That's great. So when you look back at the years that you've served, is there one person that came before you that you'll always remember? And probably it was the most difficult one that you faced.
You know, it wasn't, and unfortunately, it happened a number of years ago, so I don't remember the employee's name. But one of the interesting concepts we have on our practice is that sometimes we have the insurer dealing directly with a client who is not represented. And when they settle their case, even though I'm the lawyer for the insurance company, I have to prepare their lump sum papers. I have to walk them through to make them understand what the lump sum process is. That I have to explain to them why I think it's in their best interest, but the judge is going to be the one who's ultimately going to determine if that settlement's in their best interest. And I know I've had probably 3 of those that all stuck out for the same reason, is that normally that process could be, here are some papers, show up in Fall River, I'll talk to you 10 minutes ahead of time in the lawyer's room, and we'll go through this, which is not the right way to handle that. I took the time to meet with that person by telephone, to meet with them afterwards, after they had received the papers, reviewed them, said, call me, let's talk about any questions you have. I want to make sure you're comfortable with this. And meet at the DIA a half hour in advance just to go over any last minute questions and to present that settlement. And at the end of 3 of those settlements, the amount of thank yous and appreciation I got from those people, that you didn't have to do this, you're working for the insurance company, you could have just said, here, sign this and take your chances with the judge. And they appreciated that I talked them through it. They weren't my client. I was not giving them legal advice, but I was doing the best I could to explain it. And to me, those are some that really stand out. And the other one I would put is more of a general concept that when I was managing the workers' comp at Liberty, that we did as more of an empathetic process, was with all the opioids that we have involved in the workers' comp system. We have many employees who are on long-term opioid medications. They get sent to a medical doctor chosen by the insurer who says, this person no longer needs that opioid. And I've got an adjuster saying, can we cut that off? And my feeling has always been, and the policy that we developed at Liberty was, no, we're not going to unilaterally cut off an addictive medication. Even though the DIA system was not built to do this, what we do is we file what the DIA is called a Form 108. And that's the form you file to discontinue weekly benefits from an employee. But we would submit that form in, and in the explanation box say, we're looking to discontinue or modify their opioid medication. And the DIA understood what we were doing, and they allowed us to file those, which then got us before a judge for an impartial medical exam before any determination went on what was happening with that person's medication. And to me, that was a policy that I was happy that we implemented because it was a humane policy. And even though the insurer was paying for these medications, maybe for longer than they should have, it prevented someone from being cut off and trying to find another source to get that medication, which is only going to lead to bad. And to me, I think that's one of the things I'm probably proudest of that we did.
Well, I'll tell you, everything that Omar said about you, I saw when I read your resume and when I talked with you. And I won't vote for anyone if they don't have compassion and empathy, and you certainly have it. And you know, I have to say, I'm not politically correct, and I have to tell you that, you know, we are getting good people coming through like you, and I'm so pleased. And I've been here long enough to know the political friends want to be on the district and superior court, so they don't jump the line. That's why we've got you. That's why you're qualified, and you deserve it. The thing is that, you know, I'm looking at you must be out every day, whether you're before the courts or whether you're in industrial accident board. You've gone before the industrial accident board, you've gone before the district court, the superior court, the appeals court, in Rhode Island too. So, so it must be every day that you're appearing.
Certainly, until the last 18 months, yes, it was. The last 18 months, it's been a lot more by Zoom with less commute, but yes, I'm in the courts. I was in the courts for years on a regular basis, which to me was invaluable because I got to see how other judges ran their courtrooms. I got to see how various administrative judges at the DIA ran their courtrooms. And you get that knowledge base of, if I was sitting in that position, how would I run my courtroom to be respectful to the litigant and also respectful to the attorneys? That there's an argument that you may not think is going to go somewhere at the end of the day, but you have to respect and let that person move at their own pace. At the same time, learning some cues about, I understand that this to me seems to be like what you're talking about. Is that what you're talking about? And maybe get that reined into a more manageable system. But that's something I love that I've been out in the courts and seen. I've seen judges handle cases that I've liked the way they've done it. I've seen judges handle stuff that I would probably do it differently. At the end of the day, I've won cases, but at the end of the day, I've practiced a lot of mass workers' comp, which for the insurer attorney does not provide many glaring wins that you get. But at the end of the day, if I lost a case, but I read that decision and I saw that the judge understood what I was arguing, understood the points I was making, understood the cases I was raising, but at the end of the day said, well, your arguments are right, but I found this witness more credible than yours. I can live with that. I can walk away from that case and feel good about what was done. And that's how I would want people to feel, to make them feel they were considered. And really, that's what I've seen from being in the courts as much as I have.
Well, I think the hundreds of cases you've had, I'm pleased that you've been involved with drug addiction. I mean, it goes to every court, people are drug addicted. How about with mental issues?
We certainly, on the workers' comp end, we have them. It's a little more difficult in workers' comp because, and not to get too into the act, but there are two basic mental health type claims you have at the DIA. One is it's a straight psychological claim that is the only injury, that's the only source of disability. The act as it's currently written says that work has to be the predominant cause of that disability. And it's very interesting to read medicals and see how that predominant cause can be built. If it arises from bona fide personnel decisions, that could disqualify those claims. So again, our personnel decisions bona fide. Then we have a second class, which are ones that the mental illness flows from the work injury. So I've got depression because I'm not getting better and I'm not at work and I want to be at work and I'm not. And that's a simple but-for causation. And that is a very important component because people do want to go back to work. And people who can't go back to work and don't feel that they're adequately providing for their family because of it, they get depressed. Because of their pain, they can't sleep and focus as much as they used to. And maybe not enough to work in front of any dangerous machinery in a workplace. So again, to me, we've dealt with a lot of that. We certainly don't deal with it to the extent of traumatic brain injury in a trucking accident case, but at workers' comp, we deal with it. It's important. And for me, I think I understand the various proofs and the various types of claims that are easy to consider and of the ones that are more difficult to consider. Those are going to be medically complex. We're gonna need to see what all the doctors have to say. Those cases probably don't fit in as the impartial being the be all and end all. And certainly I'm willing to dig into those medicals and read them and review them and determine what I find is the more credible medical opinion and apply it.
I'll tell you, I'm so pleased, your age, your qualifications, the life experience you're bringing, hundreds and hundreds of cases you've had in all areas. Now, this would be hard to answer, but in all your years of legal work, is there one person that came before you, one case that was the most difficult that you'll always remember?
Yeah, there was one that it was a very difficult case. It was actually down in the Fall River DIA before Judge Brendamule. And it was a worker who was driving to a job site from his home and got involved in a head-on collision and killed. And he had a young child who would, if the injury happened in the course of employment, would have been able to collect benefits. And the difficult thing about that case is that the Workers' Comp Act has a coming and going rule that if you're on your normal commute, that's not the course of employment. And really having to struggle with, this is a case that I'm having to make a defense on the going and coming rule, and this should not be compensable, while still dealing with a young child who is not having any support because the mother, now there were some issues with the mother as well, that she was unable to work, and I believe she was only on SSI. So it was not a huge payment. And that was a difficult one because of what was involved. And it was a case that at the end of the day, if that case got tried at the DIA, and actually we did do the hearing at the DIA, but it was one on its best day, maybe a 60% chance that the insurer wins that case, 40% not. Judge Brendamule, very compassionate person. I knew that Judge Brendamule, if there was a way that she could find that the going and coming rule didn't apply, she was likely to do so. And going and coming rule is always a difficult one because that's one when going and coming was created, it was created back in the days where people had a fixed place of employment. They went from home to their place of employment. They went home. Over the years, it's morphed into what our current work is, that not many people have fixed place of employments. Not many people have a fixed commute, and the law has expanded to make more and more of those cases compensable. And me having to have a discussion with the insurer to say, I don't think we're going to win this case at hearing. You know, you think you are, but we're not. We're going to have to take this up on an appeal. If we take it up on appeal, do you want this being a case that might issue a written decision that is more far-reaching than this singular case? So to me, that was the most difficult one because my employment, my attorney-client relationship said, fight this case, deny this case, take this case to the Supreme Court if necessary. But at the same time, I had to have those discussions with the insurer in such a way to explain to them what the potential pitfalls were. And even though that might be the way that the case should go, is that the case that you really want it to go? And that was a lot of hard discussions before we got that case resolved.
Well, I mean, there's there's no question that I can ask you that, that even comes up that I question your ability. It is amazing. Your questionnaire is amazing. The whole legal, years has been involved in this particular avenue. And I can't be more pleased that you applied and you're appointed. And I know Omar is thrilled. I mean, we've been asking to fill those positions for so long and so well too. So I'm really pleased that that you were appointed. It makes it a little easier for me for the ones on the district court and superior court that shouldn't be there. So but it was such a pleasure to meet you. And again, Omar was so disappointed he couldn't make it, but there wasn't enough he could say about you. And so I'm very pleased for you, really. Thank you so much.
Thank you.
Thank you. Before I introduce Counselor Duff, my only suggestion, sir, I'm actually, I think, the only one of all the counselors who does workers' comp. I think you make it a little too complicated. When you talk about the going and coming, it's like way over people's heads. So if you could make your answers a little simpler. You did mention Judge Brennemuel. If you could be 90% as compassionate as Judge Brennemuel, you'd be doing a great job. There weren't many judges as compassionate. And my understanding, talking to the employee bar, Judge Brennemuel was a judge. If she could find a way, should rule for the employee. And I just hope that's the type of judge you're going to be. Counselor Eileen Duff, any questions?
I apologize for being late. Traffic is back, which I think might be a good sign for the economy. You have a great resume. You're eminently qualified. I'm going to touch on some of the questions that Councilor Iannella and I spoke about to the last candidate who was up for the same court. And that is, and in fact, there was a great article in the Globe about it this morning. The nature of work has forever changed. And you will be facing new challenges as a judge of maybe even on that very rule, because he is the Councilor Iannella is an expert on this, but when are you coming and going if you're working at home? Right?
Right.
And so, what happens if you have a slip and fall at home? Have you had a chance, and this is not a trick, but have you had a chance to think about this or have discussions with other attorneys or folks about this? Because you're entering a whole new realm of law, I think, or the way of the law will be read. And by the way, I want to go back just 1 second. Thank you. I'm not an attorney. I appreciate your explanation from before. I'm always an advocate for the underdog. But what I think one of the most important yet challenging jobs that all of our judges on any level have is the reading of the law. In that we as citizens don't always like what the law says. And we might think it's unfair, but it is the law. And we see that over and over and over again, folks, hang them high, we don't like that decision or whatever. And some of that will perhaps happen to you and your family may get some of the residual effects. But as long as we have separation of powers, which hopefully we will continue to have, and we live in the greatest state in the country, as far as I'm concerned, a fine commonwealth. But the reading of the law and for the judges to have the independence to do that, we don't always have to agree. And many times we don't understand, but that's not our job, it's your job. So I appreciate you speaking about that because I think it's really important. And we see that happen, as I said, on every level of the courts. People come before us and say, he was unfair, he was rude, he was this, he was that. Sometimes that's the law. And that's just what it is. So I appreciate you explaining a little bit of, as compassionate as we want to be and as much as we'd like to do this, there are rules and we have to stay in those parameters. So now that I've given you that speech, back to the question about the new 21st, 22nd, whatever century we're in today, way of work, because we are forever changed. And if you have not had a chance to read the report that came out, it is published today in the Globe, and it's really fascinating. I'm a realtor, and it really impacts us a lot about we're in a whole new world that none of us have ventured into right now. We think we have, but we have no idea.
Yes, and certainly as the administrative judge, and as a lawyer's practice, it's something that we're always considering in, we're always looking at it. We're always asked questions by the insurer about what ifs.
Yeah.
That if a claim happens in another state on a similar issue, no. Invariably, the question comes out, what happens in Massachusetts? And in my practice, what happens in Rhode Island if that
Yeah.
case comes up? So we discuss all of that. And I think one of the things at the bedrock of the Mass Act, of course, is as an administrative judge, the legislature is the one who develops the intent. And the legislation has the opportunity to be amended to fit better than a case-by-case decision, and does it stand up to appeal. That being said, the law still says what it says, and even on those differing work environments and differing work conditions, it still comes down to many of those exclusions use the phrase having a fixed place of employment. And that's going to be my question as a judge. Does this person have a fixed place of employment that they're going to? If they don't have a home office, a home office, corporate office that they're going to on a daily basis, then they don't have a fixed place of employment. And theoretically, any travel that happens in the course of their employment is going to be considered work-related. And I think that's what we're looking at, that although what we see about how the world operates may be different, our act still uses that term fixed place of employment, which is something that will be scrutinized very carefully.
Absolutely.
And that will allow for a lot of these differing work situations to be considered to be work-related, compensable, because of the fact that the person did not have a fixed place of employment that they had to check into each day.
Right. And with the new virtual world, which we will not leave, we may be hybrid, but we are never going back to how we were. And a lot of that there were a lot of benefits for that. There's been some big challenges, but there've been some really wonderful benefits, even in the courts, who've been stretched to the very limits. By having to engage technology, we have collectively learned some lessons of how maybe we can engage that technology to be positive going forwards in particular areas. And this is why I think your resume, meaning not just the words and everything, but your life experience, is going to be very important to us on this board. And I think our legislature, just from what you've even said, is going to be challenged in a way that they haven't been challenged since the Industrial Revolution, as far as what is work. What is work? What does work mean? Every single thing about it. It's I don't know if you've ever read any of Peter Drucker, but he's an economist and a work philosopher of who's spoken a lot about this thing in a different way before this global pandemic, which we are still in. I just think it's going to be a challenge, and it sounds like you're up to the challenge, and it's really just going to be it's also going to be a tremendous opportunity. I know that you have said you don't have anything published, but I do encourage you to use this opportunity, if you so feel or the spirit moves you, to write things about this, because this is new law. It's a very, very exciting time. The workplace in the United States of America has not changed this much since the Industrial Revolution. It's mind-boggling. It really is mind-boggling. So great opportunities all around, and Godspeed to you, because it's people may look at these jobs, that's light lifting. No, it's not. You're going in for something where every fiber of your intellect will be used, and probably the fibers of your soul will be challenged as well, because we don't have, it's a new course that we're charting. So I applaud you and thank you for applying. It is very important that people step up. You certainly could probably do very well financially in private practice, so coming to offer your services to the Commonwealth is greatly appreciated by me. And I have no further questions, Mr. Chair.
Thank you very much. Few questions, just quick answers if you could. There's no question, times have changed. People are now going to be working at home. Is there any dispute? I asked this a week or two ago, the nominee. An employee alleges, or states, I should say, he got hurt at work or she got hurt at work. At home, at home. I slipped and fell in the kitchen. I mean, put the medical records aside for a second. Putting, like I said, aside, obviously there's no witnesses. I mean, how do you dispute that employee's claim that he or she got hurt and slipped and fell on a wet floor in their home? Am I missing something, or on that part of it, that it's work-related? You agree?
Yes, because the only person who's testifying is the employee. They're the only credible witness. They are furthering employer's business, compensable.
And as long as the medical records state, obviously the injury and the medical records state there's disability from one period to the next, I assume you got to put that person on. Am I right?
They will be put on benefits at the conference level. On those facts, yes.
Okay, thank you. And you may not know this, I'm sure you do, but just in case you don't, it's totally fine. Because it's not a trick question. The first part you probably know, obviously, they're doing, I think, conferences and hearings in person now. And they're doing conciliations virtually. These are changing times. And my understanding is, I'll tell you, but you might know anyway. There's now going to be, did you know about it? You probably did, a virtual day for conferences. 1 day a week is virtual. From my understanding, you tell me if you agree or disagree, now you live in Worcester. And, you got, for whatever reason, you got a couple of kids. I'm not feeling great today. Oh, lousy weather out. You know what? I don't want to go to Boston for my conference tomorrow. I'm going to call Judge Sherry up and say, listen, can I do this next week on Tuesdays? That's virtual day. Any problem with that? And is that your understanding at least?
Yeah, I haven't read the details about whether it has to be agreed by both sides, but
That's not.
I'm open to doing conferences virtually. To me, no, the hearing on a credibility issue is the one that I would need in person. A conference, I feel over Zoom, we've done it enough, or WebEx, we've done it enough. We can see, we can tell, and if that's going to be the way to get it done most efficiently, I'm open to it.
Yeah, no, I agree. And for whatever reason, it could be childcare issues. I don't want to drive. I got my kid home from school sick. It's legitimate. I don't know if it had to be agreed by both sides, but it seems to me, well, what if this insurer always says no, and this insurer doesn't seem fair? But that's the way of the future. And I talked to Omar about this. I said, you may find out, but I don't think you will, because you may need more than a Tuesday for virtual. But then I said, probably not, because the employee bar, the employer bar, they like the camaraderie. I think it's good myself when they're in person. You develop friendships, and it's a way to really eventually to move the cases because you form relationships. So I think that's good. You've done 3,500 cases. How many cases, I know you worked in Rhode Island as well, practiced in Rhode Island. How many Massachusetts workers' compensation cases have you handled?
Probably
About
12 to 1,500.
Okay.
Because the caseload was about 150 when I had a
Yeah.
full caseload.
And always on the employer side?
Yes, employer insured, yes.
If you had to guess, just speculate, a guess, how many of those cases did the judge not issue either 34 or 35? Did you get any?
I was going to say, of the 1,500, there were probably a good half of them that we went into the conference with already agreeing on a proposed order.
Okay.
And of the other half,
I'm talking about the ones the judge had to, I mean, you mentioned, or somebody mentioned Judge Ma, Judge Brenda Mule. I can, I'll give you my assessment at the end, talking employee attorneys and employer, but I'm curious as to,
yeah, I would say,
that you went straight out, denied.
and I would say, and again, if we take the asbestos cases out of the mix too, because those tend to, everyone takes denials at conference, maybe 4 or 5% where there was a legitimate questionable issue about, someone playing soccer during a lunch break and those type of things, or just not having a medical that was
Okay.
remotely.
I agree, I agree with you. I agree. And, yeah, that's fine. You know, I talked to a lot of employee attorneys. The people I did speak with, Stephen Brandemule, Bill Nealon, folks at Ketchy's, they all like you. This guy's going to be good. This is the best employee judges I think we've had in a long time. We had some bad ones. They weren't fair. They wouldn't give an employee a break. I like this, the judges we have now. There were some issues with some judges. Obviously, they didn't get reappointed because people didn't think they were fair. It's all about being fair. But I don't have any questions. I think you're going to do a great job. Just remember the employee. At the end of the day, they got to go home. They got a family. They got a kids. Close call. You got to give it to the employee. At least I hope you do. But again, thank you. Good to see your wife here, Attorney O'Malley, and we will take this up at the next council assembly, and best of luck to you and your family.
Thank you all for your time and consideration.
Thank you.
Thank you.
Thank you.
Thank you.